Hello. Thank you for listening to the November 2021 episode of My PIP Monthly. My name is Amber Rouse Holloway, and I'm a partner here at our Troy office. Our November 2021 topics include, of course, a case law update. For the case law update, we will be discussing the unpublished opinion. All of these are actually unpublished opinions. The first one we're going to talk about is Auto Club/Member Select v. Farm Bureau, then Hensley v. Auto Club, and then Atkinson v. Kretler. And then after that, we will discuss the trending topics in PIP litigation, speaking very general but some specific circumstances of motorcycles and the No Fault Act. First up, we have the case of Auto Club Insurance Association/Member Select Insurance Company, the Farm Bureau General Insurance Company of Michigan. This is an unpublished opinion by the Court of Appeals that was just recently issued on September 23rd, 2021. This case addresses what's commonly known as the one-year back rule and other statutes of limitations that may apply in situations of subrogation. Here, Plaintiff Auto Club appealed the trial court's order granting summary disposition based on defendant's Farm Bureau's argument that plaintiff's complaint was barred by the statute of limitations in MCL 500-3145. Plaintiff was seeking reimbursement from Farm Bureau after it learned that defendant/claimant Shamoon's husband had a no-fault policy with Farm Bureau. So essentially, Plaintiff Auto Club paid benefits, and then after they paid the benefits, they learned that the claimant had insurance that may have paid for no-fault benefits. And that insurance was with Farm Bureau, so they were seeking to recoup their payments made. The court here explained that whether the one-year statute of limitations in MCL 3145 applied or the 6-year statute of limitations in MCL 600-5813 applied turned on whether Farm Bureau was higher in priority. If Farm Bureau was higher in priority, then plaintiff's action was a subrogation accident and 3145 applied, thus barring plaintiff's claim. If plaintiff and Farm Bureau were equal in priority, then plaintiff's action was seeking recoupment under 3115, and therefore MCL 600-5813 applied, thus rendering plaintiff's claim timely. Pursuant to MCL 500-3115, an action for recovery of PIP benefits payable under this chapter for accidental bodily injury may not be commenced later than 1 year after the date of the accident that caused the injury unless written notice of the injury has been given to the insurer within 1 year of the accident, or unless the insurer has previously made a payment for PIP benefits. Pursuant to MCL 600-5813, all other actions shall be commenced within a period of 6 years after the claims accrue, and not afterwards unless a different period is stated in the statutes. So they're referring to unless MCL 500-3115 applies. So here, an insurer has 6 years to file a complaint seeking to partially recoup PIP benefits paid from an equal priority insurer. An insurer has 1 year to file a complaint based on subrogation from a higher priority insurer. So that's when the court here needs to decide whether it is a claim for subro or a claim for recoupment. All right, so here the plaintiff's policy language is what was key to determining the applicable statute of limitations. Defendant Shamoon originally sought benefits through her sister's policy with plaintiff. Under plaintiff's policy, a named insured included assigned drivers if the vehicle to which they were assigned to was the involved vehicle. Defendant Shamoon was an assigned driver on her sister's policy, and the vehicle to which she was assigned, a Dodge Journey, was the involved vehicle. Therefore, defendant Shamoon was expressly defined as a named insured on plaintiff's policy. Farm Bureau went on to try and argue that defendant Shamoon was merely an assigned driver, citing case law that holds that assigned drivers are not the person named in the policy or the named insured. However, the court explained that these cases were distinguishable because plaintiff's policy expressly included assigned drivers as named insured, whereas in the cases that were mentioned, they were not. The policy did not address this issue. Farm Bureau also attempted to argue that plaintiff pled in its complaint that it was asserting its subrogation rights against Farm Bureau as the higher priority insurer, and therefore it should be limited to this position rather than its position in response to Farm Bureau's motion for summary disposition. The court, using Farm Bureau's own citation to find in favor of plaintiff, explained that plaintiff's complaint is that it was seeking reimbursement for no-fault benefits paid that Farm Bureau should have paid. Accordingly, the court found that defendant Shamoon was a named insured under plaintiff's policy, and therefore it was an equal priority with Farm Bureau. Therefore, because plaintiff was seeking reimbursement and not subrogation from an equal priority insurer, the 6-year statute of limitations and NCL 600-5813 applied, and plaintiff's complaint was timely. Moving on to the case of Hensley v. Auto Club Insurance Company. This is again an unpublished opinion per the Court of Appeals that was issued October 14, 2021. Here, the Court of Appeals affirmed the trial court's order granting summary disposition in favor of defendant Auto Club. The Court of Appeals affirmed the trial court's ruling that filing a police report within 24 hours of an occurrence of an automobile accident was a condition precedent to claiming uninsured motorist benefits. In this case, essentially, the Court of Appeals highlights the distinction between PIP and UN benefits. Uninsured motorist insurance permits an injured motorist to obtain coverage from their own insurance company to the extent that a third-party claim would be permitted against an uninsured at-fault driver. Here, an individual may recover PIP benefits by statute, but in order for an individual to seek UN benefits, they must follow the terms of the contract/policy. By way of background, this case involved a hit-and-run automobile accident that occurred on August 8, 2017. The plaintiff here reported the accident to the police. The report listed a created date of August 10, 2017, and this was 2 days after the alleged accident occurred. At the time of the loss, plaintiff did have UM coverage through Auto Club, and in March of 2019, plaintiff filed suit alleging that defendant was liable for UM benefits. Subsequently, defendant filed a motion for summary disposition, arguing that plaintiff was not entitled to UN benefits because he failed to make a police report within 24 hours of the accident and failed to establish that the at-fault driver was uninsured. These requirements were condition precedents to UM coverage. Plaintiff did not file a response, nor did he appear for the hearing. The trial court therefore granted defendant's motion. Thereafter, plaintiff filed a motion for reconsideration, arguing that plaintiff made a signed written statement to the police within the first 24 hours of the accident. The trial court denied plaintiff's motion for reconsideration for lack of palpable error, and plaintiff appealed. And the issue on appeal was was there a genuine issue of material fact as to whether plaintiff made a written report of the accident to the police within 24 hours as required by the policy. The Court of Appeals highlighted the Rory v. Continental decision, which states that UN benefits are optional as a matter of contract and not mandated by the No Fault Act. For those reasons, the contract dictates the conditions under which UN benefits will be provided. In this matter, the UN policy in relevant parts stated that an individual making a UN claim must, 1, provide the carrier with legal papers served in connection with the lawsuit, and 2, make a written report of a hit-and-run accident within 24 hours of the accident to allow for vehicle inspection if needed. The Court of Appeals relied on the unambiguous language of the insurance contract and the police report dated August 10, 2017, which was attached in support of defendant's motion for summary disposition. The date was clearly outside of the 24-hour window, and the Court of Appeals further opined that Plaintiff's motion for reconsideration was not persuasive because plaintiff submitted a handwritten statement sheet dated within the 24-hour windows, which recounted the facts of loss. The court opined that there was no way to verify that this document was signed and dated on the date plaintiff alleges. Therefore, in this matter, summary disposition was proper. And lastly, for our case law update, we have the case of Atkinson v. Kretler. Here, the court affirmed the trial court's decision in part and held that, pursuant to the policy language between AAIC, which is the American Alternative Insurance Corporation, and plaintiffs, the UIM limits were only for compensatory damages, and an award for interest for non-payment is not subject to UIM limits. The court remanded for modification of plaintiff's award due to a duplicative award of interest under prejudgment statutory interest. In addition, the court affirmed the trial court's decision and held that the sudden emergency doctrine did not apply to the present facts here because defendant Kretler created the sudden emergency after being repeatedly advised of his reckless behavior prior to the collision. By way of a quick background on this one, cases were consolidated and they stem from a motor vehicle accident that occurred on November 11, 2016, when a 2003 Saturn Ion owned by defendant Kretler was driven erratically by him and collided with an ambulance driven by plaintiff Atkinson and occupied by another plaintiff, Felecki, and occupied by another person that was unfortunately deceased, Carolyn Maines. The accident resulted in the death of Tyler Kretler and Carolyn Maines. John Maines was named as a plaintiff for the personal representative of Carolyn. The AAIC insured the ambulance with the UIM coverage at a limit of $1 million per accident. After a trial, a jury returned a verdict of almost $1.5 million in compensatory damage for all three plaintiffs. The AAIC then filed a motion for judgment, notwithstanding the verdict, or a JNOV, declaratory judgment, remitter, and an apportionment of damages, arguing that 1, plaintiff did not present evidence proving that AAIC breached its policy to be compelled to provide coverage, and 2, the terms of the policy with the insured provided a maximum of $1 million, and since defendant Kretler's insurer allegedly tendered $50,000, the maximum verdict should be $950,000. 3, that the sudden emergency doctrine should apply to Kretler's action prior to the motor vehicle accident. The trial court ultimately entered a judgment for compensatory damages in excess of $1 million in favor of the plaintiffs. In essence, the trial court awarded the maximum UIM limits along with awards statutory prejudgment interest pursuant to MCL 600-6013 and interest under the UTPA pursuant to MCL 201. The AAIC appealed each of the post-trial judgments, and defendant Kretler cross-appealed, challenging the trial court's denial for tentative settlement between himself and plaintiffs. The court affirmed the trial court's findings that the AAIC is required to provide coverage and reasoned that the trial court provided jury instructions advising that defendants have admitted that they are liable for damages, leaving the sole remaining decision of determining the amount of damages to be awarded to plaintiffs. Defendants did not object to these instructions during trial whatsoever. The policy language found in AAIC's UM section stated that the insureds are legally entitled to recover compensatory damages only insofar as the policy limits, which were $1 million. Additionally, the language provides that there will be no duplicate payments under the coverage for any element of the loss. The court explained that compensatory damages were in fact contractually limited to $1 million, but that litigation costs such as case evaluation, sanctions, and here UTPA interest are not defined as compensatory damages. Thus, the policy limits do not include litigation costs. Additionally, the record did not establish $50,000 was actually dispensed by Vincent Kretler's insurance to the plaintiffs, leaving the full $1 million properly on the table along with litigation costs and the interest. And then with regard to the sudden emergency argument, The court found that the sudden emergency doctrine does not apply here because it's described as an extension of the prudent person standard within the context of a sudden unexpected event that was not of the defendant's making. It provides a rebuttal of the presumption of negligence, essentially. The court held that the trial court made an error in ruling that the sudden emergency doctrine is an affirmative defense. Nonetheless, the trial court reached a sound, legitimate conclusion by holding that the sudden emergency doctrine was not unexpected, but rather of Tyler Cretler's own making. The deceased Tyler Cretler was driving in an erratic and unsafe manner prior to the collision, and he was repeatedly informed of his behavior by an occupant of his vehicle prior to the accident who exited the vehicle out of fear for her own safety. Therefore, a reasonably prudent person in his position would have ceased driving. Even though the defendants introduced 2 affidavits from medical experts indicating that Tyler had an unexpected neurological event before the collision, the court found that there was sufficient evidence to show that Tyler was lucid and was aware of his actions prior to the neurological event. This case was a mouthful, but essentially what the big takeaways are that UIM policy limits exclude litigation costs and interest. I would argue that most insurance policies that have UM/UIM coverage, the language does provide that there will be no duplicate payments under the coverage for any element of the loss. There's mostly language that states something along those lines. However, here the court explained that litigation costs, such as case evaluation sanctions, are not defined as compensatory damages, and that only compensatory damages will be covered by the policy limits. Moving on to trending topics in PIP litigation. This month I wanted to talk about motorcycles and the No Fault Act. Generally speaking, pursuant to MCL 500-3103, an owner or registrant of a motorcycle shall provide security against loss resulting from liability imposed by law for property damage, bodily injury, or death suffered by a person arising out of the ownership, maintenance, or use of a motorcycle. It goes on to say that each insured transacting insurance in this state which affords coverage for a motorcycle, as described in subsection 1, also shall offer to an owner or registrant of a motorcycle security for the payment of first-party medical benefits only in increments of $5,000. These benefits are payable in the event the owner or registrant is involved in a motorcycle coverage. Here you have most motorcycle policies have some sort of PIP coverage, generally speaking, in increments of $5,000. And that's without the No Fault Act. That's generally speaking what covers motorcycle insurance. Further expanding on motorcycle insurance, pursuant to MCL 257658, a person that's 21 or older that operates a motorcycle is not required to wear a helmet if he or she has a motorcycle endorsement on his operator's license for not less than 2 years. So 2 years or more, you're not required to wear a helmet, or if the person passes a motorcycle safety course. Further expanding on MCL 500-3103, MCL 257658 indicates that a person that's 21 years or older does not have to wear a crash helmet as long as they pass a motorcycle safety course, or as long as they've had a motorcycle endorsement for 2 or more years. Further, a person that's riding on a motorcycle is not required to wear a helmet if he or she has the $20,000, not less than $20,000 in PIP coverage, and that's if they do not have a rider. If they do have a rider or passenger, then they must carry $20,000 per person per occurrence in order to not wear a helmet. And now moving on to motorcycles and the No Fault Act. So the prior slides discuss motorcycle insurance, generally speaking, on its own, and what requirements a motorcyclist has to have if he or she decides not to wear a helmet. And here, under the Michigan No Fault Act, an insurer is, and we've all heard this before, an insurer is liable to pay for benefits for accidental bodily injury arising out of the ownership, operation, maintenance, or use as a motor vehicle. The Michigan No-Fault Act does not define motorcycles as motor vehicles. Thus, in order for an insured motorcyclist to recover first-party PIP benefits above or in addition to, depending on the facts, the coverage on the motorcycle itself, the accident must arise out of the ownership, operation, maintenance, or use of a separate motor vehicle other than the motorcycle. So basically, the motorcyclist, the incident or accident must have occurred with a motor vehicle. Pursuant to MCL 3114, Section 5, a person that suffers accidental bodily injury from a motor vehicle accident that shows evidence of the involvement of a motor vehicle while the operator or passenger of a motorcycle shall claim personal protection benefits in this order of priority. 1, the insurer owner of the registrant of the motor vehicle. 2, the operator of the motor vehicle. And then 3, if you still can't check either one of those, the insurer of the operator of the motor vehicle. And then lastly, the motor vehicle insurer or the registrant of the motorcycle involved in the accident. And then pursuant to the no-fault reform, these old rules still apply, but any policy within the order of priority that does not have an allowable expense coverage is excluded. So if they don't have the PIP coverage, then you just take that policy out of the order of priority and just keep going. If there's no policies in the order of priority with allowable expense coverage, then motorcyclists must seek benefits from the MAIPF. And here it is again that in order to claim PIP benefits from the No-Fault Act, the injured claimant must show the evidence of involvement of a motor vehicle while the operator or passenger of a motorcyclist. And that goes, a lot of times you see this issue in motorcycle accidents in general. Most motorcycle accidents are caused by motor vehicles, just by the nature of how accidents happen. Motorcyclists are generally on their own, and then they get, sideswiped, but it does not have to necessarily, the motor vehicle and the motorcyclist do not necessarily have to have a head-on collision for that involvement to take place. The motor vehicle can swerve and then cause the motorcyclist to swerve, for example. But ultimately, there must be some sort of involvement, and depending on the facts of the circumstance, what involvement qualifies needs to be discussed. And there we have it for the November 2021 episode of My PIP Monthly. Again, my name is Amber Rouse Holloway. I welcome any questions or concerns you may have. Again, I'm a partner here at our Truro office. Thank you.